Lankin?
Do I have an opportunity at this point to explain my abstention?
And if you wish, Senator Lankin. Please.
Yes? Thank you very much. I heard a no over there, so I wasn't sure. I just want to make it very clear that I take no joy from it being passed, nor would I have taken any joy from the amendment being defeated. I generally support the rationale and the reasons that were put forward for this. I think it is an abominable example of us failing to do our job of sober second thought. I think when something comes in at the end like this, is distributed not as per the agreement a day before, so that we had the opportunity to understand unintended consequences. I think that it is not within our competence to take a snap vote like this, and I'm disappointed that we behave in this way from time to time in the chamber.
Resuming debate, Senator Boisvenu.
I was part of working out an arrangement among 4 groups in how we were going to do this. And I take exception with Senator Lankin said that we did something that was not as per the agreement. We had an agreement that we would try to do certain things as good as we could, and that it would not always be possible, and that this is one of those examples. So for her to say it's not as per the agreement is absolutely false.
Senator Boisvenu, on debate.
Be modest.
On debate.
Speech. No, I try to be modest.
Mr. Speaker, I rise to speak today regarding an important issue, the act of any ticketing provision for young people for possession and distribution of cannabis. The reason that I want to speak to this is that in Bill C-45, there is legalization of marijuana, but there is no actual decriminalization implication, because for a young person who has any more than 5 grams, it will not be possible for police officers to do anything but to have the youth be dealt with under the criminal system. This could happen in your family or to someone you know. The Senate Legal and Constitutional Affairs Committee heard from a number of witnesses that talked about the problem with this. For example, we had Mr. Robichaud, who told us that this was a problem because if a young person had more than 5 grams, it was automatically a criminal act and would be dealt with by the criminal system. Michael Spat, another defense lawyer, told us that because there was no ticketing regime for young people for possession and distribution, the clause, the bill, was in fact unconstitutional. So this is a major gap. Many lawyers have said that Clause 5 was unconstitutional. We heard about this last month. In fact, it contravenes Section 15 of the Charter, and we were told that young people are in fact more negatively affected with harsher sanctions than their adult counterparts for the same offense. They don't have access to the proportional sanctions and rehabilitation and so on that they should have. The Quebec Bar Association told us that a regular criminal process was being imposed on a very vulnerable population. And that means that 2 objectives of the bill are being violated, and that is to have youth exposed to criminal sanctions and reduced harm.
And I quote, "Youth would again be treated differently and could possibly receive a stricter sentence or at least have more interaction with the criminal justice system under the Youth Criminal Justice Act." End of quote. I repeat, more interaction with the criminal justice system. This is why I propose an amendment. L'amendement proposé vise à donner aux policiers le
The proposed amendment gives police the option to ticket young people or to have them involved in the youth criminal justice system if they have over 5 grams of cannabis and are under the age of 18. Over 5 grams, it would not be the option. We should let the police have the option of using a ticket instead of having young people dealing with the criminal system if it is less than 5 grams. Let us put ourselves in the shoes of parents and grandparents. We don't want our young people in our families in the legal.
It includes youth and the sort of discrimination going to offense the charter. This is why I tabled an amendment. Que je vais chercher.
And I'm looking for it right now. Here it is. So in Bill C-45, I move in clauses 12 and 51, pages 14, 28, and 29, that Bill C-45 be not now read a third time, but that it be amended in clause 12 on page 14 by replacing line 27 with the following. 10 in parentheses, subject to section 51, every young person who contravenes subsection 1 and B in clause 51 on page 28 by replacing lines 30 and 31 with the following may be commenced by a peace officer, and on page 29 by replacing lines 15 and 16 with the following: the contravention of any of paragraphs 8(1)(a), B, and C, or any of subparagraphs 9(1)(a)(1), 3, and 4, and B, 1 and 2 in respect of B, by replacing lines 21 and 22 with the following: B, proceedings in respect of an offense arising out of, and C, by replacing line 33 with the following: 9(1)(a)(1), 3, and 4, and B, 1 and 2. In amendment, it is moved by the Honourable Senator Boisvenu and seconded that Bill C-45 be not now read a third time, but that it be amended. A, in clause 12 on page 14 by replacing line 27 with the following: 10, subject to section 51, every young person who contravenes subsection 1 and B in clause 51.
Senator Eggleton, you had a question?
Yes, I do.
Une question?
No, Senator Boisvenu, I couldn't agree with you more in terms of we don't want to criminalize our young people. We don't want to give our young people criminal records that are going to destroy their lives. There's no doubt about that. That's one of the reasons why in our committee we adopted an amendment that was suggested by Senator Seidman. And she said, Section 5, subsection 1, for greater certainty, nothing in this act is to be considered as limiting the operation of the extrajudicial measures that are provided for under the Youth Criminal Justice Act. Now, when I read the word criminal in the name of the act, it gives me pause. But those extrajudicial measures involve charging a young person. Police and prosecutors are specifically authorized to use various types of extrajudicial measures like take no further action, informal warnings, formal warnings, a letter to the parents, things like that. Isn't that a better provision than slapping young people with fines of maybe $150, which they can ill afford?
Sénateur Boisvenu.
On a pris connaissance de...
We were made aware of the amendment proposed by the committee, and the problem is this. it doesn't exclude from the criminal process, and the current act means that it will leave traces in the judicial system, and if you have a second or third offense, the first one will remain. But this ticketing would mean that when you receive a ticket, it would, because you sold a certain number of grams, it would disappear from the system. The problem with a youth is that it would remain in the system. And Senator Poirier.
Here today in support of Senator Boisveneu's amendment to add a ticketing option for our youth when it comes to single possession and distribution. One of the objectives and intent of Bill C-45 was to protect our youth by changing the approach to recreational cannabis from criminal perspective to a public health policy approach. When looking at the bill as drafted today, and after hearing from numerous witnesses at the Social Affairs Committee, I am concerned that Bill C-45 doesn't fully reach its objective, bringing our youth away from criminal justice system. I had the opportunity to be a member of the Social Affairs Committee throughout our study of C-45, and as the proceeding went along, the concerns over the impact of the criminalization on the youth's socializations were growing. Whether it was with the disparity of the criminalizing of behavior of youth but not for adults, or having only the Youth Justice Act as an avenue, when a youth has over 5 grams, C-45 punishes and criminalizes a youth along the way. Not only do we need to protect their health, we also need to protect them from being criminalized due to a simple mistake of having 6 grams of cannabis on them instead of 4. As Corey O'Soup, advocate for the Saskatchewan Advocate for Children and Youth, said on April 25th, and I quote, "Last, we have concerns about Clause 8 of the proposed act regarding the criminal offense for cannabis possession as they relate to the youth. The current legislation makes it an offense for youth to possess more than 5 grams of cannabis, while for adult, an offense does not occur unless there is a possession of 30 grams or more. While we support the objective of reducing youth exposure to cannabis, we have concerns that this could lead to heightened criminalization of the youth." End of quote. And I believe, honourable senators, that Mr. Kirk Tousaw from the Tousaw Law Corporation said it most clearly on May 24th, and I quote, "As a parent of 4 children under 18, this comes from my heart. We must not criminalize young people in our pursuit of our laudable goals of trying our best to keep them safe and give them the tools that they need to make reasonable choices." End of quote. And I would also like to quote Emily Jenkins, Assistant Professor, School of Nursing, the University of British Columbia, who appeared as an individual on April 25th, and I quote, "Additionally, there is strong evidence that the social cost of criminalization are profound and disproportionately affect youth, particularly Indigenous and racialized youth and youth in marginalized communities. These harms include stigmatization and exclusion, limited opportunities for meaningful employment, worsening levels of poverty and poor health outcomes, and all while exhausting limited public resource. As of right now, Bill C-45 only provides for the Youth Justice Act for a simple possession of over 5 grams. And the Senator Boisveneu's amendment, we are reducing the risk of criminalizing of our youth, protecting them from the path of the justice system, but mostly offering them a fair penalty without long-term consequence. For most of the youth with a simple possession at 14 or 15, whichever age under 18, it will be their first experience with our justice system. Do we want them to feel the full weight of it from a young age? As Mr. Tousaw again made clear the point of the impact of involving the criminal justice system for simple possession cannabis, and I quote, "We cannot make the impacts of that usually dramatically worse by also involving them with the criminal justice system. Involvement with the criminal justice system for a simple possession of cannabis provides no benefit to the young person. In fact, it's all negative. You become fearful and resentment of the police. You become entangled with the criminal justice system. You might have a lifelong criminal record. where you might not be able to cross the border into the United States. Future employers might turn you down. There are a host of negative consequences that arise simply because we've chosen to label that normal behavior as criminal behavior. And we need to take a different approach. End of quote. And that different approach, honourable senators, in my opinion, should involve a ticketing regime like Senator Boisvenu is proposing. It is the right step to take in decriminalizing a behavior and to protect our youth from the negative consequence of dealing with the justice system. The Youth Justice Act is there as an option, but more is needed for our youth. And that is what Solomon Friedman, criminal defense lawyer at the Edelson and Freeman, expressed on April 30th, and I quote, "Right now, to me, when I read this, and I've read the legislation and the legislative summary and the commentaries a number of times, I cannot for the life of me understand what the possible argument is to deny youth access to the ticketing regime. It simply makes no sense." End of quote. It also tightens up the gap between youth and adult when it comes to sanctions. As some witnesses pointed out, there were some disparities in the bill where sanctions for youth were harsher and the lack of option, especially for the ticketing, were unavailable for youth, whereas they were available for adults. As Michael Spratt, a criminal lawyer, said on May 2nd, and I quote, "The ticketing provision also discriminates against the young. They are not allowed to partake in that and will be forced down the criminal path. There will be no discretion for police officers or prosecutors to afford youth the benefit of receiving a ticket." End of quote. Lastly, I believe Senator Boisvenu's amendment would help with the concerns expressed during the Social Affairs Committee, clause by clause. When we came to this observation, which was adopted unanimously at the committee, everybody had some concerns, and I read the observation. The committee concurred with the observation of the Standing Senate Committee on Foreign Affairs and International Trade that the Government of Canada should examine Part 1, Division 1, Clause 8 of Bill C-45, by which Canadian youth are criminalized for behavior that is legal for adults. We had the government official give answers, especially for the constitutionality aspect of the Youth Justice Act and the outcome for the youth who goes through it. And from reading the transcript and from memory of the proceedings, we were not fully convinced of the answer. Whether it was on the constitutionality of the Youth Justice Act, whether it was on the long-term implication where there was concerns around it, and again, with a ticketing regime such as Senator Boisvenu's amendment, it gives that extra tool to the police and a protection from the unnecessary criminalization of our youth. So again and again, honourable senators, Senator Boisvenu's amendment is a fair and fitting amendment to improve the bill and to have C-45 attain its objective. The ticketing provides a path of non-criminalization away from the justice system for a simple possession, giving another tool to the police officers when dealing with a young person, allowing ticketable offence for youth as well, not just for adults, and furthermore protect our youth. It is my sincere hope that senators will support this fair and reasonable amendment, because at the end of the day, we all want to protect our kids, our youth, as best as we can. With a ticketing system, I believe that's exactly what we're doing, and I urge my honourable colleagues to think deeply before they vote. Do we want our youth to go down a path of criminalization due to a mistake of having a simple possession of 6 grams, or do we want to help them avoid the criminal justice system by having a ticket? Let's help them avoid a path of criminalization by adopting Senator Boisvenu's amendment of ticketing regime for our youth. Thank you, honourable senators.
Une question, Sénateur Pratt?
A question, Senator Pratt, on debate? I have a few people before you.
Ready.
Well, then Senator Eggleton on debate.
Well, thank you very much, Madam Speaker. Isn't this something? Isn't this something? We've got the Conservative caucus telling us that we're too tough on crime in this bill. Anybody who was here in the last Parliament will know what I mean. But I must tell you, I must tell you that I do share the
wrong side.
Pardon?
I am on the wrong side.
Okay. I must tell you that I certainly share the view that we want to protect our youth as much as we possibly can. Ticketing is something that is a part of this regime. I don't think anybody should get any criminal record, whatever age they are, out of possession. I think it's a health and a safety issue, and they should not be getting a criminal record. So the ticketing makes sense for the adults. I understand that, and the ticketing provision is in here. But when it comes to children, when it comes to people under the age of 18, there's a different regime that is proposed here, and it's the youth criminal, I hate the word criminal in it, but that's what it's called, the youth criminal justice system. But when I first saw that, I said, oh, no, that's not the right way. But then I got looking further into what that act and what that system involves, how it is, in fact, implemented. And we had officials come to our committee, and they talked about what it does. You know, first of all, courts generally don't prosecute minor marijuana offenses charged for people under the age of 18, noting that these cases are often dealt with through diversion programs designed to steer them out of the court system. And that's where these extrajudicial measures come into effect. They're non-court responses to less serious offenses by youth. They require the police officers to consider the use of extrajudicial measures before deciding to charge a young person. Police and prosecutors are specifically authorized to use various types of extrajudicial measures, like taking no further action, or giving informal warnings, or sending a letter to the parents, or bringing the parents in for an interview. Now, I asked Senator Boisvenu that question, and he said, yes, but what about the records that survive all of that process? Well, here, as a general rule, the Youth Criminal Justice Act protects the privacy of young persons who are accused or found guilty of a crime by keeping their identity and other personal information confidential. The protection of privacy is achieved by prohibiting the publication of information that would identify a young person's involvement in the criminal justice system and by restricting access to their youth records. On top of that, to give us even more comfort, Senator Seidman, member of the Conservative caucus too, moved an amendment at the committee, which we agreed to. Even though we had heard all this information from the officials, even though we knew this process was a key part of the bill, she moved for greater certainty, Nothing in this act will be construed as limiting the operation of the extrajudicial measures, which I read, that are provided for under the Youth Criminal Justice Act. And that was passed by the committee. It is now part of the bill because the committee's report has been adopted by this chamber. So I think that's the appropriate response to this. You get into ticketing, somebody that's 14, 15 years of age, 16 years of age, getting a $150 ticket, well, what if they can't pay it? You know, we've talked about we've talked about the fact that, and this concerns me, I think it should concern all of us as well, that there is an uneven system here in terms of who gets charged, both adults and both youth as well. It's disproportionately people of racialized minorities. It's disproportionately Indigenous people. It's disproportionately people who are living in poverty. $150 fine is not going to be easy for a lot of. So what happens then? What happens then if they don't pay the fine? What punishment comes to them then? It could end up worse than what this extrajudicial measures would be. So I think I'm prepared to give this what is in the bill now. I'm sorry, I don't support the amendment, but I'm prepared to give what's in the bill now my support on the understanding that it is going to create a much greater decriminalization for all people in possession, but particularly for young people. I believe that will be the case, so I will not be supporting the amendment of Senator Boisvenu.
Sénateur Boisvenu, vous avez une question?
Senator Boisvenu, you have a question? No, on debate. On debate. A question?
So I understand this because, to be fair, I haven't spent much time on this section. The extrajudicial sanction, if the young person refuses to participate in such a sanction, under the legislation today, it means they actually could end up back in front of a court. So if I understand it properly, I thought the ticketing suggestion was to give an alternative to extrajudicial, not to replace extrajudicial. So, because the alternative could be that if the young person doesn't accept responsibility or refuses the extrajudicial, they actually find themselves back in front of a youth court. So the question is that your intent? Sorry, it's like Jeopardy, I got to put in front of it. Is that your intent, or had you not looked at that section, Senator?
I suppose that's quite possible. I can't imagine, given the kind of measures that are involved in extrajudicial, which are essentially warnings, you've been a bad boy or a bad girl and going to tell your parents or send them a letter or something like that. I don't know why they would want to fight that and end up in a court in front of a judge. But still, as I also pointed out, that rarely do such charges appear in front of the court, and of course the courts are guided by the legislation, guided by the very measure that Senator Seidman put into the committee's discussion and was adopted, and that is in fact that limiting the operation of extrajudicial measures that are provided for under the that nothing in this act is to be construed as limiting the operation of the extrajudicial measures. So I think that's a better outcome for youth than getting into a ticketing regime they may not be able to afford to do, and the ticketing regime is more important, for the adults, and I think that's the best way to have it. I don't want anybody, as I said, to either go to jail or get a criminal record of any kind out of possession of cannabis.
Senator Bright.
May another question? And I don't disagree with what you're saying. I'm trying to get to the point, though, if the young person denies responsibility, so in other words, a young person is picked up by the police with a small quantity of marijuana and denies it's their marijuana, extrajudicial is not available to the police. So what is the alternative at that point? And I guess my suggestion is the alternative, if it's a ticket under this legislation, they'll be dealt with under this legislation. But if they do not, they'll be dealt with under the Youth Criminal Justice Act. So it will be in front of a court. So I guess, again, I just want to make sure we're on the same page, and I have to put it in form of, I hate this. Don't you agree?
Senator
Again, the way the act is written and the way it is, in fact, administered, is to protect youth. It's to prevent them from getting a criminal record or having that tag that can destroy their lives. So the system is geared towards that, and I think if the person wants to fight it and ends up in front of a judge, then a judge will have to make that decision. There are three discretion levels that occur throughout this system. One with the police officer, first of all. Secondly, with the prosecutor, Crown prosecutor, and thirdly with the judge. And so I think there is every opportunity to protect young people, and particularly with this amendment, that for greater certainty, we ask them to use these measures.
There's 40 seconds left, Senator Pate.
Senator Eggleton, there seems to be some confusion from Senator White and yourself. Isn't it actually true that you can do a warning and you can do referrals, cautions, send young people otherwise, not just extrajudicial measures? They're not one and the same. And isn't it true also that, in fact, one of the reasons most youth court judges don't actually imply fines is it's usually the parents who are left to pay the bill? And so, in fact, most would actually use the cautionary measures, the referrals, and the extrajudicial sanctions if it was seen as a more serious offense. In fact, they'd use the less serious mechanism.
Your time is up. Senator Pratt, I'm sorry, your time is up. Senator Pratt, on debate.
Merci, Madame la Présidente.
Thank you, Madam Speaker. Very briefly, I would like to oppose this amendment for the same reason that I opposed the previous one. Not necessarily because I'm in disagreement with the intention or the objective, but rather because it is a very complex amendment that is being issued to us at the very last minute, and even if we have 15 minutes before the vote, it's really insufficient. At the Legal and Constitutional Affairs Committee, we studied this issue, and we had before us the opportunity to open the fine system to youth as suggested in this amendment. And one reason why we didn't is that we knew very well that the criminal justice system, the youth criminal justice system, is one of the criminal justice systems that is most complex. It's very delicate and very complex, and lawyers spend their whole lives specializing in it, and we know that we couldn't start looking at this in isolation from the entire criminal system. And so we followed the recommendation of the Barreau du Québec, which was taken by Senator Seidman and which was passed as an amendment to the bill by the Social Affairs Committee. We thought this was a more cautious approach. Before this amendment, we're wanting about a number of questions between the new fine system, which would lead to a criminal record, which would create a bunch of questions. We don't know what it would look like, and the youth criminal justice system raises too many issues to be passed in a rush in 15 minutes without fully understanding the consequences. For example, in this ticketing system for youth, what would be the role of parents? In the youth criminal justice system, based on my understanding, and I'm very far from being a specialist in the matter, there's a predetermined role for parents, but in this ticketing system currently, there is absolutely nothing set out for parents. So I think it would be extremely incautious of us to wade into this youth criminal justice system in a hurried way. That doesn't mean it's not a good idea, but if it is a good idea, it needs to be properly reflected upon and done in a context of sober second thought and not rushed consideration. Thank you. Are senators ready for the question? Senator Pratt, would you take a question?
Position to the amendment, which I share, be reinforced were you to know that there is no credible argument that the different treatment of youth and adults in this particular area would violate Article 15 of the Canadian Charter of Rights and Freedoms as it has been interpreted over the years in an increasingly deferential manner towards the legislation by the Supreme Court of Canada. Would that reinforce your opposition to this amendment?
Senator Pratt.
I'm even more convinced.
Accepteriez-vous une autre question?
Would you accept another question, Senator Pratt?
On the rights of the child, that there should be no harsher penalty nor a harsher offense for young people. And we are bound by the Convention of the Rights of the Child, which we've signed. Not the Charter, but the Convention internationally.
Senator, that point was made in front of the Legal Affairs Committee. And again, if it is a good point, this amendment should not have been brought in at the last minute where we cannot measure the consequences of it. Well, if you want to legislate in 15 minutes things that can have long-lasting consequences on young Canadians, I'm not going to do it.
Senator, excuse me, Senator Dean, do you have a question?
No, on debate, very briefly.
I'm sorry?
On debate. On debate. Oh, sorry.
I'm sorry, Senator McCollum, do you have a question? I can't hear anybody. I'm sorry.
On debate.
Senator McCollum.
Okay, honorable senators, it is well known that a high number of youth are already smoking marijuana in Canada, and that includes a high percentage in the Indigenous youth. Why they choose to do so is an issue that has not been given a priority and not been investigated. In his book, Handcuffed by History, Gordon Cruz interviews men who were in juvenile detention centers as youth, many of them for marijuana use. Mr. Cruz worked with these youth for over 40 years and interviewed them 20 years later to see what recommendations they would make. Many of them became successful citizens, parents, and mentors, despite their history of crime, mostly because of support and resources like Mr. Cruz, and they were able to make different choices later in life. However, many were hindered by the legacy of their unfortunate beginnings, and it followed them through their lives. Many of these men recommended that other options be offered to youth, especially youth incarcerated for marijuana use. They recommended programs to provide alternative options to help youth realize the lessons that they needed to learn. These men said placing youth in juvenile detention centers just taught them to become criminals, and I think we've all heard about the legacy of prison. Choosing to do drugs remains a social issue that continues to be criminalized. Punishing a youth who has a young, expanding, and growing mind like an adult doesn't make sense. On many occasions, these children have fewer resources than other youth. Ticketing is a pretense of dealing with the problem and which stems from disobedience on some occasions. On many more occasions, marijuana is used to temper anxiety. Many of these youth and their families will not have the money to pay for the fines. Once youth is forced into the criminal life, they begin the process of remand. And when I worked up north on the reserves, the people fly out to Thompson or to the PAW to go to court. They're remanded and they fly back, all at their expense. When it comes time for the next court case, at some point they do not have the money to fly out, and then they're taken and put into prison. And and this will target Indigenous youth disproportionately. I also understand that provinces have implemented their own regimes. So I'm concerned about this ticketing, and thank you.
A question? Do you have a question?
On debate?
No, Senator Dean's before you. I'll get to you next, Senator Dick. Senator Dean, on debate.
Thank you very much. I'm glad to join this discussion. It's a very, very important one. I'm going to go back to one of the key principles of Bill C-45, which is to help kids, to support kids, to educate kids, to do better for kids than we are doing currently, to bring cannabis issues out into the light, bring it out from the darkness. And for that reason, there was a choice, there was a decision to move towards proportional responses to cannabis offences, ones that are flexible, ones that recognise that kids aren't simple, they're complex, that recognises that cannabis isn't simple, it has a number of complexities. So there was emphasis placed on the Youth Criminal Justice Act, which is world-renowned, by the way, for its approach to the emphasising the decriminalisation of young people. People come and look at it from other countries. It's something that we shouldn't take lightly. As we've heard, there are a broad range of measures outlined in the Youth Criminal Justice Act that involves taking no further action. You know, maybe 6 grams isn't a ticketing offence. Maybe it's a no further action offence. Or maybe it's an informal warning available under the Youth Criminal Justice Act. Police caution programs, letters to parents, Crown cautions, referral to programs. So when you've got the kid that can be helped, that needs help. And we've talked about access to resources, to mental health programs, to harm reduction programs. When you've got that kid in front of you, it might be easier to give that kid a ticket. Just get it out of the way, deal with it, give that kid a ticket. It's not going to be the best thing for that kid. Access to a community program, to counselling, is going to work better. Extrajudicial sanctions. When I talked, and you've heard me say this before, I've kept in very close contact with Ontario officials in terms of the close collaboration between the federal government and provincial officials as we've thought about the implementation of this legislation. What I heard was that those in the Ontario Justice Ministry were absolutely delighted with the emphasis on the Youth Criminal Justice Act because it works, they can fine-tune it, it's flexible, it offers a range of responses. And essentially the message I got, and this was several months ago, was don't screw that up. Don't screw that up for us, because it works, it's good for kids, and it will work particularly under a regime in which we are legalising and strictly regulating cannabis. So I will say no more than that, and I won't restate the request that came to me from Ontario officials who are close to the ground and who understand the realities of kids and cannabis. Thank you.
Senator Dean, would you accept a question?
Yes.
Thank you for all the work you've done on this very difficult file. Senator, from what you were saying and what Senator Eggleton was saying and Senator McCallum, is that for the young people in our country, we have set up a completely different regime. It's a system where very different from an adult court, and the right place to deal with issues of young people is in youth court and not in adult court, where it's a different regime than the adult court. Isn't that why it's important to keep those two systems separate?
Absolutely it is, and the important aspect of this is that in some cases there's diversion way before the youth court, let alone the adult court. And you're absolutely right, Senator. This is something that is available to us. It works. We should be emphasising it and using it, not looking for other alternatives. Thank you.
Senator Dick, on debate. Oh, sorry. Vous avez une question? Senator Dean, another question.
Senator.
My question is, you referred to the 5.1, okay. We've got clause 51 as well. And all the experts that came before the committee said that clause 51 was unconstitutional. Can you guarantee that no young person in Canada under the age of 18 that will be penalized? You can guarantee that?
Just like you, I can guarantee nothing. I can guarantee nothing. I can guarantee that I can't guarantee that tickets will help and they may hinder. I know that there were a number of people providing testimony at the legal committee. There are a range of views, as you might expect, on the quality of that testimony. I can only provide to you what I know about the Youth Criminal Justice Act, what those who are experts in the operation of the Youth Criminal Justice Act in Canada's largest province with a large caseload told me. And their advice was that the federal government has it right, and this is something that we should not be tinkering with because we know that it works.
Comme vous allez laisser à chaque cours, dans chaque...
Since it will be up to each province to figure out how it will deal with young people. Would it not be better to remove that possibility right away? So we take this out and make sure that young people cannot be prosecuted in that way.
First of all, I'm not sure what you're talking about. We're talking about tickets being appended to the Youth Criminal Justice Act here. So I will just restate again that, consistent with the philosophy of this legislation, which I applaud, which is to create a sophisticated, flexible range of responses to children who come into contact through cannabis with the youth justice system, including counselling on harm reduction and education, which we've heard a lot about in this place, is better than the option in many cases of a quick ticket just to get that kid out of the system. That's the problem that I have. That's the problem that experts in Ontario have. And I think that it needs to be heard here, and I'm making it clear.
Senator Dick, on debate.
Mr. Speaker, Madam Speaker, I should say. I too am concerned about the effects of cannabis legislation on youth, in particular Indigenous youth, because we know that in our justice system, including the police, the judges, and everyone involved in the criminal justice system, there is a systemic bias, and that, for example, in a recent news report based on research from the University of Toronto, it was shown that in Regina, for those who were arrested for possession of cannabis, there were 9 times more Indigenous people arrested than there were white people. And in Toronto, there were 3 times more Black people arrested for simple possession than there were for non-Black people. So there's definitely that discrimination embedded in our system. And then when you have the discretionary power and you're the police officer and you get to decide, should I give a ticket? Should I go through the youth criminal justice system? There's the potential there for bias as well, which would then probably, I suspect, favor diverting the Indigenous youth towards a youth criminal justice system. But by the sounds of it, if you were to give that youth the ticket, the $150 ticket would be something that they simply could not afford, and then they would be diverted back into the court system. So I really don't now see the ticketing option as being viable. And Senator Dean has just told us that in Ontario, the youth criminal justice system is a very robust system that acts very well. I'm assured by that. And then this is a question that I would have liked to have asked to Senator Pate. We also have within the criminal justice system Section 718(2)(e), which is colloquially referred to as the Gladue principle, so that all offenders in the criminal justice system who are found guilty of an offense, especially Aboriginal offenders, are supposed to get extra consideration for the factors in their background that might have brought them before the courts. So for Indigenous youth, then, we should have that available. And so therefore, a youth who appears before the court system, the judge, especially in Ontario, where you have a robust system, and apparently, according to another news report, there are over 100 Gladue report writers in Ontario who could say, well, this youth has come before us, and therefore, this youth should go for some kind of alternative treatment. So I'm assured, and unfortunately, I don't think the Gladue courts are evenly distributed throughout the country, and unfortunately in Saskatchewan we only have 1 Gladue report writer. There should be way more. But that, I think, strengthening Gladue reports, strengthening the court system's knowledge of Section 718(2)(e) would alleviate some of the concerns that some of us share about the effects of this bill on Indigenous youth. So therefore, I'm not in favor of the amendment.
A question or on debate?
Yes, would the senator accept the question? Yes, I'm concerned as well with Indigenous children, and the ones that can't afford to pay the $150 fine, of course, as usual, they're on social, and they're not working, there's no jobs in First Nations communities. So my question is, wouldn't there be a program like legal aid for these children who cannot afford a lawyer or if they're being prosecuted?
Senator Dick?
I think you asked two questions. One about paying the fine and one about them having legal aid. With regard to paying the fine, I'm not sure, I'm not the right person to ask that question of. I'm not sure if there are options whereby a fine can be paid by somebody else. And with regard to legal aid would be available, but of course that would vary upon whatever community that person was from.
Senator Pate.
For Senator Dick, if she still has some time.
Yes, she does. Senator Dick.
Senator Dick, it sounds like you were trying to explain the situation that happens under the Youth Criminal Justice Act, that in addition to the warnings and the ability for police to not lay charges and extrajudicial measures, there's also a presumption, I think you will know, that in fact the judges are supposed to look at every other system. So 718(2)E, there's actually even a stronger position within the Youth Criminal Justice Act that with the two, and combined with the international covenant that Senator Andrzejczyk talked about, actually puts a greater pressure on the youth criminal justice system to not criminalize young people. So in fact, there's much stronger measures there to have young people referred for treatment, to social services, to the education system, before you actually are allowed to then look at the criminal justice response. Is that not correct?
Sounds pretty correct to me, thank you.
Les sénateurs sont-ils prêts pour la question?
Are senators ready for the question? In amendment, it is moved by the Honourable Senator Boisvenu that Bill C-45 be not now read a third time, but that it be amended. May I dispense? Is it the pleasure of the Honourable Chamber to adopt the motion?
Oh, may I hear those in favor of the motion say yes? Yes. And those against? Yes. Oh, that's much stronger. The amendment is thus defeated. Well, nobody's standing up, so there's not a vote. On division? On division. Well, then, senators, I'm not being rude, but you have to start paying attention. And when I say the amendment is defeated and you're all sitting there asleep, don't get cross at me. Well, then stand up. No. Yes. Yes.
What's that? Sorry, Your Honor. It was actually hard to hear your question.
Oh, come on.
Oh, it really was.
No.
It really was. I'm just being honest. And you did.
We will do a standing vote, but I want to promise
yes?
that nobody falls asleep. And when you want to stand up for adjournment, you get up. When you want to vote, you stand up. Right. 15-minute bell. 5:31. All senators.
Call in the senators.
Call in all the